Yes,
My Lords, a couple of preliminary points before I resume. Firstly, Mr. Mills, Mr. Wilcox and I have spoken. We're still on track.
Good.
I won't bore you with the details of how we're on track.
No,
but
fine.
We'll get to where we need to be.
Good. Well, that's all I need to know. So fine, we won't go into the detail of it.
Yes, thank you. And if that changes, I'll let you know.
Yes, fine.
Secondly, the condition 7 discharge. The foul water. It was discharged on the 15th of February 2018.
15th of February 2018.
Yes. Condition
7 discharged. Do we need to see the decision or not?
I don't think so. There's nothing. No one's suggesting you do.
Okay.
If you want it, you can have it. But
no. Just if you reassure us we don't, that's fine.
Then, final question. I said before lunch, wrongly, that the phase 3 hadn't been commenced. There has in fact been a digging of a trench.
Right.
My suspicion is that again would mean that the reserve matters wouldn't be timed out if we were ultimately to win these proceedings and then get the consent, because it would be one of the exceptions to the principle.
So that would be a Whitley exception.
Yes, exactly. So that's why. So we haven't built houses, but I was strictly speaking wrong to say I hadn't commenced. So sorry about that.
No, that's fine.
My Lords, I'm going to take you now to regulation, if I may, to regulation 86, which is in tab 5 of the authorities again, page 81. I mentioned this a little bit before lunch. So authority bundle, tab 5, page 81. And it's the final bit of chapter 2, the planning chapter. And you'll see sub paragraph 1, this chapter, except 84 and 85, is to be construed as one with the TCPA 1990. And in light of that, what I next wanted to do is show you section 72 of the TCPA 1990. That's in the additional clip at tab 2. In my submission, this supports my approach that the discharge of a condition is not the consent, authorisation, etc. And you see it's section 72, subsection 1. Conditions are described as doing one of two things, and you can see those things in A and B. Regulating the development or any use of land under control of the applicant, or requiring carrying out of works to be done, and then B, requiring the removal of anything, so for example, the temporary permission or minerals, etc. So we are obviously in the context of the conditions before this court. They don't require anything to be removed or done. They are conditions which in statutory language are to be characterised under the Town and Country Planning Act as regulating the development of. And in my submission, that is certainly consistent with, that of piece with, my characterisation of, bearing in mind you read the Habitats Regulations Act 1 with this, as the condition, not the discharge, which not being the consent. The condition is how the consent regulates the development.
How the
consent, because the consent being the planning permission, the condition, yes, the planning permission imposes the condition.
Well, the permission with its conditions,
yes,
regulates.
Yes. So in my submission, that's at a piece with. I mean, it's not a knockout point on its own, but in terms of putting the jigsaw together to try and properly understand where conditions fit in this legal framework, they're not the consent, authorisation, etc. They are part of the consent, etc., which has the function of regulating.
Lord Banner, if development takes place in breach of condition, would it do violence to the language to say that it is unauthorised development?
It's unauthorised development because it's development not pursuant to the permission.
Right.
It's not that it's not that the lack of authority comes from the condition per se, if you have sense. It's because you're going off on a tangent outside the parameters of the condition.
But in the enforcement context, we speak normally of unauthorised operational development or whatever it may be, material change of use. I mean, that's normal planning parlance, isn't it? To use that language.
It is. It's a bit like an umbrella. If you don't bring the planning encyclopedia,
I
you
know.
won't need it.
I know,
Do you actually
there
accept
it
the
is.
rule? But I think 171B, that might be an unauthorised drone might be a shorthand, because
I think it's in
it's in
171B.
171B.
I haven't got it in
The
front
first
of me.
time I've been asked a question, I actually had to look at
As its
got the
uses.
benefit of the planning encyclopedia.
The notes to one of
breach
the
of planning.
sections are prayed and aid by.
Can I get back to you? It might be better rather doing on the hair. I might get, if I
No,
may.
no, fine.
get back to
That's
you on
fine.
that
But
overnight.
I want to make sure that my Lord's question has been answered.
Yeah.
So,
I'm happy
Yeah.
for you to come back.
Thank you. I might just check, because there may be some, I mean, maybe a clue against me, maybe a favour, but there may be a clue on that point in the enforcement. I want to just double check. It's not a point that's
no.
occurred to any of
I
us
mean,
actually. So far.
in a sense, it goes back to my Lord Justice Arnold's point before the adjournment,
Yes.
actually, the same question.
If you're happy for me, I think I'd rather just give you a considered answer. Remind me, so don't forget overnight. Thank you.
Okay, fine. We'll come
So
back
that's
to that.
86.
Yeah.
Can I just, while we're in that clip, also show you section 92, which this may have some import on the directive EU points too. So section 92 has provision in relation to outline planning permission, which of course this is not a grant of reserve matters, but one of the points the court may have to grapple with is the position in relation to discharge and conditions different to reserve matters. So you see there specific provision in relation to outline permission with the reservation for subsequent approval of reserve matters. The reason I draw your attention to that is when one goes back to section 70, a different part of section 70 of the 1990 Act, in tab 2, so tab 2 of the main authorities bundle. Again, interpreting, bearing in mind the duty to interpret the regs at one with the 1990 Act. We see in subsection 70, subsection 1, which is not a part of section 70, the court's looked at so far today.
Yeah.
When an application is made to local authority planning permission, subject to, amongst other things, section 92, which is as outline permission, they may grant permission either unconditionally or subject to, which I've mentioned before, such condition as they may think fit, or refuse permission. So in terms of the determination under the Act, there's the grant of permission, there's the outline, section 92, and conditions amongst things regulating development, section 72. There's nothing in the Act specifically dealing with discharge of conditions. And that again in my submission is at a piece with my submissions actually under ground 2 in terms of the conditions effectively setting the rules for the discharge as opposed to wider considerations, and it's also consistent with the Act, with which the regulations have to be construed as one, the Act treating the consenting or the authorisation as the grant of permission. Whether it also includes the grant of reserve matters as a component part of the grant of permission ultimately doesn't require to be determined, because this isn't an RM case, but it's a potential differentiating feature of this case from some of the cases my learned friends rely upon, which are reserve matters cases. So just ask you to bear that in mind when I do the trip through the case law.
Right.
Next point, my lord, would be back in the judge. So really pulling together my points on the reg standalone before we get to the precautionary principle directive. The judgment below.
Yeah.
So Sir Ross Cranston, core bundle 123, paragraph 47. Because ultimately, but before the precautionary principle on the EU law points, he was actually with me on the face of on the prima facie approach legislation. Paragraph 47, which isn't the subject of respondents' notice, in light of submissions which were essentially the same as what I've taken the court through up till now on the regs, on the face of it, assessment provisions are confined in their application to the planning permission stage, don't extend to discharge of conditions. They're explicit on the application reg 63, 62(1)A, subject to in accordance with, etc., etc.
It may not matter, Lord Banner, but there appears to be a typo in the first two lines. The assessment provisions of regulation, was that meant to say 63 or the regulations?
No, I think it does. I think it is correct. When you say the regulations are explicit on the application, regulation 63, I read that, my lord, as in connection with the next
question is about the previous sentence.
Oh, sorry.
First two lines of the paragraph. The assessment provisions of regulation.
I think it must be 63, mustn't it?
I think so.
Oh, I see. Yes.
It may not matter, but
or the regulations.
Yeah, I thought it must be one of those.
It must be one or the other. I'm not sure, but it can only be one or the other. I'm not sure it matters which. Because in essence, the text that follows accepts the submissions subject to the precautionary principle and the EU law points, accepts the submissions I've just made. So regulation 61A subject to in accordance with. That language means regulation 63 is subject to in accordance with part 2. Includes 71. 71 confine its remit to plans. That's the exhaustive list point. The planning permission. The result of 73 includes outline. In the face of it, it does not encompass reserved matters or discharge of conditions. The language of 62(1)B, all other plans and projects, doesn't take the matter further because this is a planning project, it's not an other project, so it's 62(1)A, not 62(1)B, etc. So I endorse what's said at 47 and say the court's not asked by the other side to depart from that. The question really then becomes whether what is summarised in the next paragraph does hold. Namely, do they hold either in light of the direct course, the directive, or purposive interpretation? Now, I deal with the second point first because the way that the judge below appeared to deal with it, he thought purposive interpretation meant actually if one just looks at the regulations standalone, they're still construed against me. And that to say, whilst you don't have to decide the rule at point, obviously your conclusions on the regulation standalone will have implications.
Well, does this depend on whether a purposive interpretation includes having regard to Article 6.3 or
it might do.
Or not? I mean, what is a purposive interpretation?
And the judgment below, it sort of elides that.
I mean, if the purpose of Regulation 63 is to transpose Article 6.3, then, you know, literally a purposive interpretation would be to look or to include Article 6.3. Would that be right? As a matter of approach?
I think so. If I understood the point, yes. The way I asked the court to look at it is it's two. So one, regulation standalone, and then two, if the regulation standalone, if they're against me, frankly, that's the end of the matter. On the grounds 1 and 3, you don't need to have recourse to the directive. I lose on those grounds. If you're with me that regulation standalone are contrary to the analysis and inspection of the parties, then the question comes. Section 4, the withdrawal, and that's of relevance, I say, hence, because even if you don't have to decide Rule Act, if you were to conclude regulation standalone with me, others would then say it follows from that going forward.
Forgive me, Lord Banner, the difficulty with dissecting the analysis in that way, and maybe you're right, but the difficulty with doing it that way may be that one of the purposes of the regulations, it might be said, the purpose of the regulations is to give effect in domestic law to the directive. And therefore, I'm not sure that there is a clinical dividing line between a purposive construction standalone and having regard to the directive.
Dansk Industry might actually illustrate the answer to this, and I'll take you to it in a second. The distinction is, my lord, is and imagine we're in a full EU, imagine we're 5 years ago, essentially. They are conceptually different because you can only construe the wording of the directive. So there comes a point where you can't make black say white. You
Yeah.
can't, and then, rather than it becoming a question of interpretation of the domestic transposing regulations, one simply has direct recourse to the European provision. Now, you end up, all roads lead to Rome, you end up with the same outcome, but analytically it's different. Analytically it's not interpretation, it's direct recourse to the European provision. And this is a case, I submit, where that analytical distinction may matter in one of two ways. It matters if I'm right on the proper construction of the withdrawal legislation, and even if I'm leaving aside that, it would matter to future cases. Now, so I hear what you say about the court not wanting to make a decision on the Withdrawal Act, but obviously others will be looking at your decision, trying to work out what it means going forward. And the greater the clarity is as to what the analytical route is it a interpretation of the regs or direct recourse to the directive, the more useful it will be to those seeking to interpret and apply your judgment to decision making going forward in the Withdrawal Act climate, if that makes sense. Because it would be unfortunate if we had to spend 2 more years having to litigate the same point under a different piece of legislation. So can I, against that background, take you to Dansk Industry, and that's tab 20 of the authority. And I think in light of my lord, I was going to take you to the AG first, but I think in light of your question, my lord, I'll take you to the judgment first, because that might corroborate the answer I've given. So the CJU start at page 759 of the law report, 346 of the bundle. The 31 is looking at, well, the whole passage actually from 28 through 31 is looking at the principle of harmonious interpretation of domestic law, whether or not transposing actually, but obviously all the more so with transposing legislation. Harmonious interpretation with European law. And 31, if you see 3 lines down, apply methods of interpretation recognised by rules of law to interpret the domestic legislation so far as is possible in light of the wording and the purpose of the directive. So far as possible comes, I mean, it's not a million miles away from human rights, the approach to law and interpretation of...
No, but Section 3 of the Human Rights Act was drafted with Singh in mind.
In mind, yes, it's actually the same, it's all on all fours. 32, it's true the court has stated this principle interpreting national law in conformity with EU law has certain limits. Thus the obligation for the court to refer to EU law and applying the relevant rules, this is the point where the AG goes into more detail, which I'll show you in a moment, is limited by a general principle that cannot serve as basis for interpretation national or contra legem. And then 37, if it's impossible to interpret the national provision in a manner that's consistent with the EU law, that you disapply that provision by direct recourse to the European measure. So you end up with the same, say all roads lead to Rome, you end up with the same outcome, but analytically it's different.
Well, I'm not sure I understand that. What that's saying is that if you really can't, then you just have direct effect of the directive, because there's been a failure to implement the directive correctly. That's nothing to do with having regard to the directive in interpreting domestic legislation. The interpretation exercise comes at paragraphs 31 and 32.
Sorry, I may have misstated that. That was really my point, is that step 1 is to try and achieve law and interpretation in indirect effect. Yeah. If the wording of the domestic legislation makes it simply impossible to do that, then step 2 is direct effect.
That I understand. What I'm focusing on at the moment is whether there is any clean line that can be drawn between a purposive construction and having regard to the directive in construing
So
domestic legislation. I'm not sure there is, because the purpose of the domestic legislation is to implement the directive.
yeah, but it may have that purpose, but it may not. Its wording may not achieve that purpose.
Yes,
May not be capable of achieving that purpose, and that's really where. So what I highlight in response, my lord, is 32 of the judgment. Also 43, just to highlight, re-impresses the point.
43 of the judgment.
43 of the judgment, and I'll
Yeah.
take it to the AG. In light of all the foregoing, the answer to the second question is EU law is to interpret between a national court adjudicating a dispute between private persons falling within the scope of this directive, when applying provisions of national law to interpret those provisions in such a way they may be implied in a manner that's consistent with the directive, or if such an interpretation is not possible, and as to that I say C32, to disapply where necessary. So it's a two-stage analysis, and I'd encourage that same, the reason I've given, encourage that same sequence of steps for the court. Of course, the second step involves consideration of section 4 of the Withdrawal Act, which I'll come to. Can I just take you to the AG? Can I show you their paragraph 49 on page 333? 746 of the law report. The AG 49, the court stated in this connection the requirement to interpret national law in conformity with EU law is subject to certain limits. Thus, the obligation on national court to refer to the content and purpose of the directive when interpreting and applying the relevant rules of domestic law. I suggest here it clearly has in mind transposing legislation as well as the general legislation is limited by the general principle of law, particularly that of legal certainty. Obligation cannot serve as a basis for an interpretation of national law contra legem. And then what that means is then dealt with a couple of pages later at AG 67 and 68, where the AG, General Bott, to define what contra legem means, an interpretation that contradicts the very wording of the national provision at issue, clear, unequivocal wording. So in terms of where the dividing line is, to come back to my Lord Justice Singh's point, the dividing line between where you step beyond indirect effect, leasing type interpretation into direct effect is where the wording meets the description in AG 68. And my submission under this part of my case is that properly construed, the reason I given before lunch, the wording of the habitats regulations can't be squared with a requirement at the discharge of condition stage for appropriate assessment. The reasons I don't reiterate them, but fits in essence for the Cranston paragraph 47 reasons that to do so would undermine regulation 62(1)(a), subject to in accordance with it would undermine regulation 70(1), 70 brackets 1, because the list, and it would undermine 2 and 3 because of the way you deal with it up front.
Sorry, it cannot be read as requiring assessment at the reserved matter stage, you said?
At the discharge of conditions.
Discharge of conditions stage.
I mean, also reserved matters what that's worth, but all of them also at discharge of conditions. On one view, there's a potential different. One view, it could be said that reserved matters are different in EU law. In domestic law, they're not, because it's very clear under section 70 regulation 70 subsection 3 that even when it's an outline application, you deal with everything up front.
Right. Are we heading in the direction of Barker at some
Yes,
stage?
we are. We're just about to go. There's one step, which is the Withdrawal Act, and then we're in Barker.
Right.
But Barker's EU law, we're here with looking at the interpretation of the regulations
Oh, I
on
understand, yes.
their own.
No, I get that.
So that's down to industry. So I'm turning then to the interpretive directive points in Barker and Co.
All right.
The entry point for that, my lord, is the Withdrawal Act. So I just want to show you that tab 6. And the critical section purpose of this part of the case, in essence, what we say is if we're right on regulations, read alone, there can't be direct recourse to the directive by virtue of section 4(2). So that's where we say the interpretation regulation standalone plus section 4(2) get us home on this part of our case. Section 4(2) qualifies for one, any rights, powers, liabilities, obligations, etc., which are immediately before IP completion day, which was changed to January 2020, are to be recognised and available in domestic law, enforced and followed accordingly. So obviously this has been repealed under the Withdrawal Act. Then subject to section 2 carves out from that continuation of those things. This does not apply to any rights, powers, liabilities. My sense would be obligations is the right one of these, but obviously whatever they are, but rights, liabilities, obligations, restrictions, remedies or procedures that doesn't apply insofar as, amongst other things, B, they arise under EU directive and are not of a kind recognised by the European Court or any domestic court, and then brackets whether or not is an essential part of the decision in the case. And what I say by opening on this point, I will come back to taking the case law, is they have to be both arising under the directive and of a kind recognised by the European Court. So simply saying, well, it's Article 6(3), which has direct effect, in my submission is not enough. There has to be of a kind recognised by the court. And what this means, particularly in the latter words, is there has to be recognition of the kind of obligation, etc., in question. Now, that recognition of the kind of obligation in question can be obiter, not ratio. See the final words.
But of a kind is quite a broad formulation, isn't it? Of a kind.
It's well, they have to rise under the directive and be of a kind.
Yes, yes, yeah.
Little has I'll come back to that in light of the. I really like to describe as broad or narrow. It is what it is. My key point, and you'll see where this is going, is. There's got to be something more than just. What I do say, it's got to be something more than it's a right under the directive, because they've got to be under the directive and be. So it's not a question of just looking at the text and say Article 6(3) is there. Article 6(3) was there, and before it's had direct effect. It's got to be. Is there a obligation that's been recognised by the European Court? Is the obligation to, so let me reform that, is the obligation to do appropriate assessment at the discharge of condition stage in the Habitats Directive context? So requirement, discharge of conditions, habitats, three things, three aspects. Is that of a kind that's been recognised by the court?
Is there authority on this point?
No, my learned friend Mr. Wolf says there is, but the authority before the court, it's common ground. So can I show you that next, actually? That's AB 28, authority 28. So Mr. Wolf's, I don't need to go to a skeleton, but he refers, it's paragraph 41 for your note. He refers to a employment case called Hughes, and this is the only authority before the court on this. And can I ask you to turn, please, to Law Report 225. Bundle 603. There is it's touched upon in the Harris case, which I'll come to later, but they don't look at the actual interpretation of section 4. But paragraph 15, just under D, it's common ground, for the purpose of these appeals, common ground to the extent that points an issue to an interpretation, application, etc. Brexit doesn't have any impact because of section 4(2)b. So the 4(2)b analysis in that case, which is the case the Secretary of State relies upon, was actually common ground.
But this is all, section 4.2b, is this right, is about the doctrine of direct effect?
It's not just, no. No, that's how they calculate.
That's what Hughes says.
It relates to whether in this case it's possible to rely upon the directive directly in circumstances where the regulations are with me.
So that's assuming that the regulations are with you.
Yes, yeah, they're not.
So I'm talking about a prior stage, and
Yeah.
maybe we're at cross purposes, so forgive
Yes.
me, Lord Banner.
Sorry.
Before you ever get to the doctrine, let's suppose we were still in the EU, it's 10 years ago, right?
Yes.
Before you ever got to the doctrine of direct effect, so far as directives are concerned, you first had to go through the Singh process of compatible construction.
Yes.
And that's what you've just been showing us.
Yes.
Now, if that's this, if it's that first stage that we're at, then is this right? We never reach section 4.2 paragraph B of the
If I
withdrawal.
fail at that first stage, yes.
Yeah.
I've got to get, you've got to be, by the time we get here, you've got to be with me on the proper interpretation of the regulations, I call them standard. Well, I say standard.
I know you call them standalone, but just bear with me for a moment. Suppose we're against you. That standalone doesn't just mean reading the words on the page, but that it also includes having regard to the purpose.
And I accept that it does. I accept that.
Right?
Yeah,
Fine.
absolutely.
Okay.
Accept there should be.
So I think therefore we're at one, that if we're in that territory, section 4, subsection 2, paragraph B of the Withdrawal Act is not material.
Correct. Yes. Yeah. So for this to still be a sort of live, to get to this point of the analysis, you have to be with me and the judge and say it doesn't seem to be contested that on a black letter reading of the regs, my interpretation is correct. And with me that no matter how purposive an interpretation you give the regs, you stretch the letters to breaking point.
Right, that's very helpful.
And if you're not with me on that, we don't get here.
Understood.
If you are, we do.
Yeah.
Does that answer the question?
It does very much.
Thank you. Thank you. Let me just check where I've got done Hughes. Can I ask you now just to look at the judgment below again to show you where in my submission the court went wrong, with great respect to the judge. It's paragraph 51. And then I'm just going to highlight, if you like, the entry point, and then I'm going to take you to the round trip of the European cases, and then we're pretty much on the home straight. So 51, which is core bundle page 124. Article 6.3 continues to have effect. In the Harris case, Mr. Justice Johnson held, and I'll take it to Harris later if I need to, that the requirements of Article 6.3 were accepted as binding. Well, obviously they're binding, they're requirements of a directive. And Article 6.2 and 6.3 are related so as to be of a kind with each other. The demands of section 4.2b are therefore met. My criticism, with great respect to the judge, is that's an oversimplistic analysis of section 4.2 in the situation we have to be in for this to be relevant. And obviously we may not be if, as per the question my lord just asked me and my answer to it. But if we are at this stage of the mind map, then in my submission, the question isn't whether Article 6.3 is binding. It is, as I formulated it earlier, is an obligation, as opposed to it being something parties can agree to, but is a requirement or obligation to do appropriate assessment at the discharge of conditions, not RM, but discharge of conditions stage, in the habitats context, as opposed to EIA, of a kind that's been recognised by a court prior to the relevant date, whether obiter or ratio. That, in my submission, is the proper question that section 4.2b throws up in the event we get to this part of the analysis. And the answer to it is no. The reasons I'll now show you. And by way of overview to this tour through the case law, which I'll do as concisely as I can, you've obviously had the preface in the skeletons and the judgment, but by way of overview, most of the cases that are relied upon by the judgment below by my learned friends don't relate to the Habitats Directive, but to the differently worded EIA Directive. There's some overlap, sure, like this Venn diagram. There's definitely a bit in the middle, but they're not commensurate. So most of them relate to habitats, not EIA. And those that do relate to habitats.
Sorry, most cases do not relate.
Sorry, do not relate to
Put it
habitats.
the wrong way
They relate
round.
to EIA, not habitats. Sorry, wrong way round.
Yeah, most cases do not relate to habitats, they relate to EIA. Yeah.
Secondly, virtually all of them, if not all of them, are reserved matters rather than discharge of conditions. And we've seen the statutory underpinning of reserved matters is different. See section 70 brackets 1 and 92. And thirdly, the domestic cases, as we'll see, concerned particularly, most specifically Wingfield, but also Swire, a situation where the developer and the local authority agreed, technically as a voluntary appropriate assessment, as opposed to the local authority saying, we're going to require this, and because you can't satisfy it, you fail. So whether for any one of those just differentiating factors individually or cumulatively, it matters not. My submission is that we're not in a situation where there's been a recognition of the kind of obligation in question. It's too much of a, essentially, it's too much of a read across. It might have been a read across that might have worked in in an earlier era. It might have been. It might. You don't have to decide that, but it's too much within the context of section 4.2. That's essentially my submission, and what I'll now do is do the guided tour through the case law to try and make good that submission. And there's a few bits and pieces about legitimate expectation as well, which will inform my last submissions on Gleeson and Noble, etc. So I'm going to start with Barker. And just to give you a heads up, there will be Friends of the Irish Environment, then into Environment 1 of the 3 EU cases, and then the domestic cases. So Barker is at tab 15 of the book, please. Sorry, forgive me, it's 14. We need to go to the CJU first and then the House of Lords. The head note provides an adequate summary of the facts. In essence, as you'll see from D to E, there was a application in the Barker case. There's also a fraction, but the facts of Barker, there was an application to develop a leisure complex at Crystal Palace. There wasn't an EIA at the outline stage. So there's a council meeting where, this is a letter E, reserve matters discussed. Some councillors wanted to carry out an EIA. Legal advice was that you could only do it at the outline stage. I should say now the regulations, the EIA regulations actually provide for expressly reserved subsequent applications, they're called. They didn't at the time. So that it couldn't be done. And the question was essentially, was that a breach of EU law, having regard to the definition of development consent, which I took you to before lunch. That's in the additional clip. Next stop is paragraph 22 on bundle 220, law report 768. You see there the then provisions of the domestic regulations, now differently worded, where planning permission was the only stage at which EIA could be done. And interestingly, the approach taken was not that you could loyally interpret that, but that you had to have direct recourse to the directive, which may be instructive on the earlier parts of the analysis in this case. Then at 38, page 223 of the bundle, 771 of the law report.
Sorry, 88.
38.
Oh, sorry,
38. Question 1.
Yeah.
Whether classification of decision as a development consent turns exclusively on national law, i.e. the EU law context, having regard to that definition that we saw. Did the national categorisation matter? Perhaps unsurprisingly, the European Court said no. And then we see at 42, second and third questions, whether it's appropriate to consider whether the relevant provisions of the directive, as in terms of requiring an EIA to be carried out if following the grant of outline permission, it appears at the time of approval of reserved matters, the project's likely to have significant effects. And then the court's analysis that follows in reaching the answer yes is grounded in a analysis of the specific requirements of the EIA directive. It's not grounded in general principles of EU law. Obviously, I'll come on to the cases that look at to what extent there's a read across, but I simply ask the court to note at 43 and 44 that it's a fairly textual, I might even dare say uncharacteristically textual approach by the European Court, which is of course of relevance when we're looking at of a kind, bearing in mind we're in a different directive with different text. And that follows all the way through really to 46. And then 47, refers back to the earlier Wells case, where national law provides for a consent procedure comprising more than one stage, one principal decision, one implement decision. Now, in that context, the factual matrix, the matrix of that was the outline permission reserve matters, the approach of section 92, which is of a different quality, we say of a different kind, to conditions to which 92 doesn't relate. So that's Barker. It's EIA case, textual, and reserve matters, not discharge of conditions. The House of Lords judgment that followed is the next tab 15. And obviously was it in the context of that judgment. You'll see it in the head note on page 471 of the law report at B. Again, perhaps telling you in the context of some of the early analysis in this case, it wasn't a question of stretching the wording of the 1988 regulations, which were, of course, intended to transpose. Their purpose was, just as the habitats regs was here, their purpose was to give effect to the EU obligation. The answer was not to stretch their wording and do what is effectively urged upon you here at the earlier stage of the analysis. In this case, it's to say that they were unlawful. And again, you see at the end of C, reserve matters stage. It's all about reserve matters, and one sees also at the judgment. There's a point made 22, paragraph 22 on bundle page 242, law report page 480. This is Lord Hope's judgment. And you'll see there it's clearly at the end of F, the need for EIA at the reserve matters stage. Very much reserve matters case will depend on the extent to which the environmental effects have been identified at the early stage. So there's nothing here that deals with discharge of conditions. The other thing to bear in mind, of course, is that as well as the definition of development consent being different, in EIA, the obligation is to take into account habitats, obviously where the obligation is engaged, if there's an impact, the citing tables don't grant. So it's a little easier when one reads Lord Hope's discussion about how EIA would inform reserve matters. It's easier to see how it could be applied in a way that doesn't sort of do violence to the structure of planning, because you still take into account the EIA, albeit within the context of the decision you have to make. It's a different kind, I would say, of obligation, So at the reserve matters stage in the habitats context, it's not simply taking into account, or not indeed discharge a condition, not simply taking into account, but actually it holds up the grant of consent. There may or may not be good reasons for taking that approach, but it's a different kind of obligation, to use section 4 language, to say that at the subsequent stage the information can be a showstopper as opposed to relevant consideration. Different kind. So much for Barker, unless you have any questions. Okay, conscious of the time, I'll take you now to the Irish environment case, which is at tab 27. Now, the facts of this case are really quite important because it's really a new consent. So look at the head note first of all. Following an initial, this is page 563 of the authorities bundle. Initial consent in 2008. The Irish Planning Board granted an additional period of 5 years for the construction of an LNG facility. The original consent hadn't done a habitat assessment, despite it was in the vicinity of a relevant habitat. Importantly, note about 7 lines in the bottom, that consent expired in 2018. Doubtly works having carried out. And the additional period of 5 years was then granted to carry out the project. So just pausing there. This isn't a question of a subsequent approval to a parent document. Effectively, there's a zero baseline. The lawful authority for the project had fallen away and they were re-granting. So it's a very different scenario, again, of a different kind, to use the relevant statutory language, to the situation in the present case. The questions the court set out on page 583 of the bundle, 391 of the law report, paragraph 21. I don't follow up on the law, but just to help you get your bearings of the case, that's where they are. But there are some aspects of the questions I'd like to draw to your attention. And note that does the overarching first question, does the decision to extend the duration of the development consent constitute the agreement of a project, so as to trigger Article 6.3. But in that context, one of the factors the court was asked to consider, C2C, was the original period of development consent has expired. No work's been carried out. I mean, this wasn't really an extension, it's a new permission. So this new permission point clearly featured quite centrally in the way that the debate had been framed by the domestic court to the CJEU. And it also featured in Advocate General Cocotte's analysis. So I should have said, no, that is the court. If you go to page, give me 1 second, 575. Yes, so we are in the court now. Go back to Advocate General Cocotte, 575, Law Report 383. In that regard, it's primarily practical importance that the 2008 development was granted pursuant to British national law, which didn't properly implement habitats.
You're reading at which paragraph?
AG 42.
42, thank you.
draw attention to AG 41, the expiry of the single consent had been introduced to AG 41 as well. And then AG 43, having said that eventually because the earlier consent, which had expired, hadn't done an HRA, it didn't provide, if you like, a get out for the need to do a habitats assessment and appropriate assessment for the new application. Paragraph 43, the principles of legal certainty and protection of legitimate expectations don't lead to a different conclusion. The conclusion having been, you got an expired consent that didn't do the job properly, you've got to do the job properly now. Why did legal certainty and protection of legitimate expectations not lead to a different conclusion? This is because, she says, the legal certainty and any legitimate expectations based upon the 2008 development consent could relate only to the period during which the gas terminal could be constructed pursuant to that consent. However, that's now lapsed. See the next paragraph. Now, just to foreshadow where I'm going on that point, because I'll come back to this in the context right at the end of my submissions, that my submission, legally coherent analysis in pulling all of this together in terms of what the position should be, is under the regs, in the context of a planning permission, you have to do the habitats assessment up front. If it's not done, or it's done inadequately in a legal sense, that can be judicial. The court has jurisdiction to correct that legal error by way of claim for judicial review or statutory review, depending on the context. If there hasn't been a judicial review, or if there has and it's failed, and it's wrongly failed, after the expiry of the relevant time limits, see Noble, which I'll take you to later, the decision has all the effects of law of a formal decision. It's formally valid. The court can't, nobody can question it later. We don't go back wondering if we'd made a mistake in the past, if the time limit has expired.
Well, that's the principle of certainty.
Exactly. And but the principle certainly has two aspects to it. There's public administration, so we don't go around chasing our tail. But also there's a concept of legitimate expectation. Planning permission is a valuable right. Hence the kind of reference you've seen to the SMEs, the House Builders Federation, evidence that all these SMEs who've bought the land into construction contracts, etc., they now can't develop their property. It's a valuable right, interference with which, as Advocate General Cocotte recognises in this paragraph, has consequences in terms of legal expectations of legal certainties during the lifetime of the consent. And that's the context in which I also rely upon Gleeson. I say I will take you to these cases later, but I think it may help for me to give you the headlines now to see, so you see where it's going. Whereas Gleeson, again, where permission was issued by mistake by an inspector who'd actually been told to leave it for the Secretary of State, it had been issued, and this court said, because it's even though it'd been an unfortunate situation, not on one level contrary to public administration, for this decision to be issued, it had been issued, and the only way to deal with now is through revocation. So I just flag where I'm going on that point, that the proper approach is to say you can challenge. If you don't, then the principle of validity, etc., kicks in for those reasons. Let me just carry on the talk, because there's other aspects of this case that are relevant. Can we go back to the CJEU, please, paragraph 28. Excuse me. So the court here, in considering whether there has been a project within the meaning of Article 6.3, interestingly, not whether there's been an agreement of the project, but just whether this is a project, which isn't quite the issue before this court, different kind even. Says the concept of project can be taken into account in the concept of EIA. So in understanding what Habitats Directive project means, EIA project can be taken into account. Now again, in terms of putting this into Section 4 Withdrawal Act territory, one we're not dealing with project, we're dealing with agree to in the habitats, and whether case law on, such as Barker, on development consent could be read across. So it's not actually the same subject matter that's been read across, and actually project is the same word in both direct. So it's qualitatively of a different kind, across different language. And secondly, taken into account doesn't mean commensurate. And again, I don't, three judges of the Court of Appeal don't need to be told that more than once. So I say that doesn't engage the section 4 recognised of a kind, etc. threshold. Just then to complete the picture of this case, it's based on fairly multifaceted judgment, so requires a bit of further consideration. Next page, 586, Law Report 394. The expiry. So the decision to extend a period originally set for the construction of the LNG facility for which works haven't commenced meets the development criteria for project. So the Court of Justice is placing reliance here on the expiration of the earlier consent. That is a key part of the court's analysis, not a peripheral factor.
So which paragraph?
33.
Thank you.
And we see that also at 38. The purpose of the consent is not to renew the consent for a recurrent activity in the course of operation, but to effectively reconsent a project, the consent for which has lapsed. So again, it's a feature which is clearly of some importance to the analysis of the court. 40 to 45, so important to determine whether a consent such as the consent at issue in the main proceeding constitutes an agreement. Obviously, it has to be read in light of that foregoing. So a consent such as that at the issue in the main proceedings is, i.e., a fresh consent for a project which currently has no extant consent. Again, not of a kind that is before this court. Discharge of conditions to an extant consent. 42, we see in the context of whether a Habitats Directive agree is informed by EIA Directive development consent, that latter definition is relevant. Again, relevant, one thing, commensurate, very different thing. Then 45, once again critically here, the original consent lapsed. It's not actually, though the court spends quite a lot of time on the point, it's not actually a very difficult point, I would suggest. It's a new permission against a zero baseline. Obviously, it's a development consent or agreement, however one defines those terms. New consent, 47. Whilst my learned friends place some reliance on the word consequently, it's a new consent under the EIA and consequently agreement under Article 6.3. That's not read in context of what's come before. That's not the court saying that those two concepts are identical. It's read fairly and in context. The court saying what you're doing here is it's a new permission against a new baseline. However one views those terms, they're obviously both court. Again, using the language of Section 4, this case is clearly, in my submission, of a different kind. If you didn't have any questions on that, I'm going to take you then to the Inter-Environment Wallonie case next. It's the last of the European cases, I think. That's 26. Tab 26. Again, on the head note to start off with to get the bearings. This is a challenge to legislation authorising restarting nuclear power production in Belgium after a period of lapse you see that in H2? And effectively what this did, amongst other things, you see in about 4 or 5 lines down, is the legislation deferred the deactivation date of a particular nuclear power station. The main issue, as one sees from the list of questions that start at the bottom of this page and roll over to the next page, the main issue was whether that was a project. Well, here we all agreed that just and farm development is a project. That's not the question. The question is whether the discharge of the relevant conditions mattered to a Habitats Directive agreement to the project. If we go to the judgment at paragraph 115, which is at page 551 of the preamble, 249 of the law report. I draw attention to the last 3 lines of 115, that there was a need to adopt subsequent administrative acts, such as the issue of a new specific consent in relation to one of the clarifications. So there was an act, legislation, and then subsequent administrative acts needed to be adopted pursuant to that legislation, including a new specific consent. And that was the language of the referring court described to the consent. You see that a few lines above. So this wasn't a case about a conditional planning permission or conditional consent, authorization, whatever the language one uses. This was a case where there was legislation pursuant to which, in relation to this power station, separate, freestanding, specific consents were needed. So again, there may be some features of the case that are of greater or lesser factual overlap, but fundamentally the context is of a different kind, and word I use for obvious reasons decidedly, to the discharge of conditions to a planning permission. When you're ready, the next stop is page 554, paragraph 140. And it'll be at the bottom of that page, when the assessment should take place. And having recited the key part of Article 6.3, it says at 141, the assessments must be conducted before agreement is given. And then again here in governing how the authorities agree, the definition of development consent is relevant. And again, I repeat what I said earlier about that word, it only goes so far. And then by analogy in that context with the court's findings on EA, if national law provides for a number of steps in the consent procedure, Article 6.3 should in principle be carried out as soon as the effects which the project in question is likely to have on a protected site are identifiable. And it was for that reason that the legislation, so this is a case actually which is more akin to a section 72 bracket, regulation 70 brackets 2 or 3 scenario. The legislation was the appropriate target of this litigation, even though there was further specific consents to follow, the administrative acts, because you front load. Now I say, well, amen to that. See regulation 72 and 70 bracket 3. I asked the court to remember paragraph 143 because Wingfield and Swire proceeded expressly on the basis that the court's understanding was there was not, in the habitats context, a requirement to do the appropriate assessment at the earliest possible stage. Both judgments say so in terms. They proceed on the wrong basis. To be fair, I'll give you the headline of this now. Mrs. Justice Lang's judgment in the Wingfield case came 4 days after this CJU judgment. So in reality, given the judgment doesn't relate to Britain, I suspect none of the counts were aware of it, and she wasn't aware of it. And then Mr. Justice Holgate and Swire seems to have just picked up what she said and run with it. So there's no criticism of them or the counts are involved, but that does, of course, temper the degree of power that those force that those judgments have on some of the points raised. That's so again, just putting that together. How does this play in the context of Section 4? Multiple different consents for the project, legislation, enabling legislation followed by specific consents. Actually, the legislation, the first stage, which the court considered was the key stage, so it does not a case about discharging conditions on the consent not of a kind. However, whether it's broad or, which is why I stuck my Lord's question about whether of a kind is broad or narrow, my submission doesn't, however one interprets it, these kinds of judgments don't recognise an obligation of a kind that is in play here. We're now going back to domestic law. Wingfield, I've perhaps prefaced much of what I wanted to say about that anyway. So it's tab 23. And the background facts are in the judgment at 4. I'm just getting our bearings with that case there. So it was challenged to a grant, not a refusal, by a objector for reserved matters. We see it's reserved matters in the 3rd line of paragraph 1 to an outline permission. Claims set for reference, and you see some key facts of 1 to 4. The grounds for judicial review are set out at 6. And they included that there was a failure to undertake a lawful habitats regs assessment prior to reserved matters, and essentially the argument Mr. Richard Buxton was making in that case was there hadn't been a reserved matters at the outline stage. There should have been. That needed to be addressed at the RM stage. There had actually been, as you'll see, an appropriate assessment at the RM stage. He said it wasn't good enough, or it was illegitimate. It was an illegitimate exercise. Then some of the key facts, again, just to get the bearing, get the context for what the judge held at 14, paragraph 14 on page 382 of the bundle. You see the original application for an outline permission that had an environmental statement for EIA purposes. And over the page, 17, you see the environmental statement had purported to be a report to inform the habitats regulations assessment. And that report is described in the paragraphs that follow. In essence, the complaint that transpired is that report screened out the need for appropriate assessment in reliance on mitigation. And what happened subsequently, as some members of the court may be aware, is the European Court, in a case called People Over Wind, held that you can't rely on mitigation to screen out the need for the appropriate assessment. You factor that into the assessment itself. May end up leading to the same conclusion, which they don't proceed, but it goes into stage 2, not stage 1. Because the original outline permission predated that judgment, they did it the impermissible way of relying on mitigation at stage 1. And that is of some use in understanding how far this judgment did or didn't go. Then
Wingfield didn't come to this.
I don't know whether there was an application for permission to appeal or not.
Well, I think there were 2 attempts to come here and both were refused permission.
Yeah, so
It's referred to in Swire.
Yes, oh yes, the case referred to Swire, thank you, yes,
Say it
that's
again.
right.
The history of
The history of the
attempt
case,
Yeah.
refers- so it didn't come substantially before this court, it didn't cut the mustard on permission. Paragraph 33 is the next stop. And you see that Mr. Justice now makes essentially the point I just made, that people over Wynne changed the previous understanding as to what stage of the analysis mitigation measures failed to be considered. And because of that, what the council did when it came to observed matters is it essentially redid the appropriate assessment, but factoring in the mitigation to the stage 2 rather than stage 1, leading, perhaps unsurprisingly, to the same conclusion, but the working out was consistent with the court's approach. Now, whether the council needed to have done that or not wasn't actually before the court to decide. They did do it, and what the claimant said is, having done it, they did it defectively, or it wasn't a legitimate exercise, as you'll see. But you'll see there at 39, more reference to the HRA of the Reserve Matter Scheme. 40, it was endorsed by Natural England. And of course, because they granted consent, at no stage the developers say, hang on a minute, you can't do this, you can't withhold by planning. That was, they were all at one when it came to the court. The developer was an interested party, saying what the council had done was something it was able to do. Again, not a situation of a kind, same kind that's before this court, where it was a appropriate assessment, a hostile, if I can call it that, appropriate assessment. Then from 42 to 66, and we see that point I made, that the council and the developer submitted that conducting an HRA assessment, which I say it was a voluntary, it was assessment done by agreement between the parties to justify the grant, as opposed to imposed upon the decision maker to mandate refusal, was a lawful, not mandatory, but lawful way in which to remedy the error. I accept their submissions. 71. Don't come as a surprise. The council could lawfully conduct an appropriate assessment at RM stage, whereas the present case is, was it mandatory, not something which could be done by agreement, and mandatory at the discharge of condition stage, not reserve matter stage. Then at 72, again, that's the failure to take into account paragraph 143 of the Wellington case. Yeah, Wellington case. So unlike the directive, Habitats Directive has no state objective. It's expected the earliest possible stage. Well, that's no longer good law, or wasn't good law by virtue of 4 days at the time that judgment was made. Which, if I'm right on the proper characterisation of this judgment, probably doesn't matter very much, but insofar as the court's against me, and with Mr. Bulls and Mr. Wilcox, this judgment is more directly on all fours with the present case than I say it is, then of course the court has to treat this judgment with a degree of caution, given 72. But ultimately, at its highest, it's a case saying a reserve matter is an implemented decision in the context of a appropriate assessment the developer didn't oppose and which was justified to support the grant of RM. In my submission, not of a kind, not least because the relevant word, remember in section 4.2, is obligation. Not could it be done, but must it be done?
I'm not sure why you're emphasising the phrase of a kind when we're dealing with a domestic case.
Because section 4.2 deals with EU and domestic cases. It's either or, so it can be of a kind recognised by the ECJ or by a domestic court. So that's why I do. Hang on, 1 second. Let me just check I've dealt with Wingfield. I think I have. Swire is the next one. That's at 32. And the facts of that case, just to get the bearing for the, again, the context for the findings, paragraph 1, there's an outline permission granted for development in November 18. The subject of the challenge, we see at paragraph 14 on A842, the bundle, was a decision to approve details of a master plan under condition 8. So it wasn't, this actually was a challenge to an approval of a condition rather than of reserved matters, albeit a condition which would inform later application of reserved matters. The master plan would obviously govern what followed under the reserved matters applications. And what it was said, actually in the neutrality context as well, what it was said, but that's by the by. Halfway down paragraph 14, there was a failure of both VIA and habitats regs because there should have been assessment prior to the discharge of condition 8. So this is the only one of the cases which concerns discharge, true discharge of conditions, as opposed to RM, which has the extra quality of section 92, and the claim failed. Claim failed. Now, why it failed is we need to see the context is at 37, where we see the relevant condition. The 37 is at pages 847 and 848 of the authority bundle. I don't need to read it out, but you get the basic sense of what that condition was seeking. And it came, much turns this analytically, but just it helps to understand the facts. This was a condition which, as I said, comes before reserved matters as opposed to the present case condition to the reserved matter, essentially providing a design framework for the reserved matters to follow. Now, at paragraph 93, so a little bit further on, 861 and 862, this is the, because of various other grounds, John, this is where the crux of Mr. Justice Holgate's analysis of the habitats ground was. You see 92, the complaint is that Natural England's change of stance in relation to nutrients, it's not just Somerset levels you'd have picked up, they've had similar advice notes in other parts of the country, meant that there should have been a habitats assessment prior to condition 8. And that was rejected. You see at 96 and 93 to 95 is the reasoning for why that was rejected. You see at the end of 93, after you reference to Natural England not objecting, you see that there was agreement between Natural England, it's 4 lines down from the end of 93, Natural England, the council, the local planning authority, and the developer, that they'd agreed that there would be appropriate assessment of in relation to nutrient neutrality at the reserved matter stage. Again, whether they were right or wrong to agree wasn't decided by that court, but they'd agreed. So effectively, they said, condition 8 doesn't require consideration. The way the case was argued, there didn't need to be appropriate assessment pursuant to condition 8 because it was going to be dealt with later under reserved matters by agreement. You then see the repetition of, with respect Mrs. Justice Lang's inadvertent mistake. No objective requiring HRA to be carried out at the earliest possible stage. And that's obviously not right now in light of Wallany paragraph 143, as to which I repeat what I said earlier. But ultimately, the issue Mr. Justice Holgate decided in that case, the arguments were framed differently, clearly. It wasn't, could the local decision maker require appropriate assessment at the discharge of condition stage, and rely upon that to refuse permission. It was whether a non-requirement in a situation where there was an agreement for voluntary habitat assessment at a later RM stage was lawful. So again, in my submission, not a recognition of any obligation of the same kind or of a kind, even a similar kind, or perhaps framed better, the obligation at issue in the present case, the obligation to do our appropriate assessment at the discharge of condition stage for habitat is not an obligation of a kind that was recognised in this case, in the Swire case. So again, putting it to the highest, it is reserved matters as an implementing decision. So putting all that together, that tour through the case of one last tour, the Gleeson and Noble, and then we're home, which just about in time. We're actually ahead of where Mr. Mills and I said we needed to be. So, but putting all that together, none of those cases that I've shown the court in my submission, either individually or cumulatively, fall within section 4.2b. There are no cases where an obligation of a kind such as that at issue in the present case, I won't repeat the characterisation of that kind because you've got it already. There are no such cases, the reasons I've given. There are either EIA cases, where there's and or reserve matters. The only one that's a conditions is Swire. You've just got my submissions on that. And the two domestic ones were essentially voluntary habitats assessments by agreement with the developer to justify the grant. So as I said, for those differentiating characteristics, whether individually or cumulatively, in my submission means that the section 4.2b is engaged, the carve out from the section 4.1 applies. Which means if we're in the scenario, which my answer to Lord Justice Singh's question some time ago, if we're in the scenario where section 4 is relevant, then there is no scope for direct recourse to a European law to escape the verbal constraints of the habitats regulations, even on a public interpretation.
The judge clearly thought section 4.2b was relevant.
Yes.
And so you say
I say he was wrong.
He was wrong.
Yes, so he was oversimplifying. He seemed to think because Article 6.3 had direct effect, that was enough. And I say no, because the question is not does it have direct effect, but does the relevant obligation at issue, namely the obligation to do AA, etc., for discharge of conditions and the Habitats Directive, is that an obligation of a kind that's been recognised? Doesn't, because remember, it's arising under a directive and of a kind.
Yes. I'm puzzled. Forgive me, Sir Bernard. No, I didn't want to interrupt you.
Sorry, no,
I was only going to make the point. It's really a matter for Mr. Mills, I think, rather than for you. Speaking for myself only, what I'm puzzled about is why the judge was going to section 4.2b at all.
Well, because on his analysis, it's probably into rise. Yes, that's probably is a matter for Mr. Mills.
Yeah.
Yes. Lastly, want to deal with, elaborate my point I made earlier about Noble and how do you put it all together and have a workable system that doesn't do sort of violence either to legitimate interests of legitimate expectations or the environment. And the point I want to make here is Mr. Moule says Article 6.3 requires appropriate assessment before one agrees to a project. There hasn't been a valid appropriate assessment here, therefore the requirement hasn't been met. And in my submission with the greatest respect, it's an oversimplification. Pull the points I made together. The true position, various subpoints here, I'll number them if it makes it easier to follow. So number one is the true position is at the earliest stage, see Wallany 143, earliest stage, the agreement to the project must be subject to appropriate assessment. The directive leaves it to the procedural autonomy of member states to work that requirement into their domestic regime, subject to principles of effectiveness and equivalence.
Sorry, you're going a little fast
Sorry,
for me.
sorry. So the directive leads it to the procedural autonomy of member states to work that requirement, agreement to the project must be subject to A at the earliest stage, to work that requirement into their domestic consenting regimes, subject to the principles of equivalence, which doesn't really apply here, and effectiveness, which are the two limitations on the principle of, two main limitations on the principle of procedural autonomy. That's my first submission. My second submission is that that's exactly what the habitats regulations do in regulation 70 brackets 2 and 3. They require front-loaded appropriate assessment at the permission stage, consistently with Wallany 143. And there is therefore, I say, no inconsistency between the regulations as interpreted by us and the directive. And third submission is that the question then becomes, what if the earliest stage assessment, i.e. the regulation 70 brackets 2 or regulation 7 brackets 3, depending whether it's full or outline permission, what if that earliest stage assessment fails to comply with the relevant obligation? So what if there's a grant of planning permission which does not lawfully apply regulation 70 brackets 2 or brackets 3, depending if it's full or outline, 2 being full permission, 3 being outline? And the answer to that in my submission is noble, formal validity. And what I distill from Noble, and I'll take you through it, is Noble holds that the administrative law principle that goes back to Hoffman, Roche, and O'Reilly and Mackman, that administrative law acts have all the effects in law of valid decisions unless until they're quashed, applies in the EU environmental law context and is consistent, this is the key point, with the principle of effectiveness. So in other words, it's a consistent application of procedural autonomy to say, in this context, your moment to do this is at outline planning stage or full planning stage with full application. If you don't do it properly, the courts can hold you into account. If no one brings a challenge, then the principle of formal validity kicks in and you assume it's been complied with. That, in my submission, is a legally coherent answer to this whole issue. I will take you through Noble, and then I'll got a couple of other points that buttress it, and then we're pretty much home and dry. So Noble is tab 13(1)(3) of the authorities. And I'll deal with the chronological point before taking the fact. Noble, as you see at the very end of the headnote, was a judgment delivered by this court whilst the ECJ's reference in Barker was penned. So it's been made, but the answer hadn't been given. So it's made in knowledge that the question had been asked, but not in knowledge of what the answer would be. When when Barker came back from the ECJ, in in the House of Lords, Noble wasn't cited. Why is that of significance? Certainly it had been said in various stages of these proceedings below. We'll see whether it's said again today that the House of Lords in Barker can be taken to have overruled Noble. Well, it must have had great precedence if it did, because it wasn't cited, nor was Hoffman and Roche, which of course was a decision of commensurate jurisdiction. So one would expect the House of Lords to at least adverted to it, nor was Iranian Mackerman. So that's the chronology. Noble, in my submission, still stands and survives Barker. There's nothing in Barker that's inconsistent with it, and their lordships didn't turn their minds to Noble. Having got that out of the way, let me take you through the facts of Noble. And again, the head note is largely sufficient. So there were two planning permissions, outline permissions. So you see in 2000, there was an outline application for a leisure development. It was a casino, not the terms on that, leisure development. Then there had been an earlier permission. You see there's a few lines further down. The site had also been granted an outline permission for a business park. The earlier permission had been granted without EIA, but there'd been no record of whether they considered. So effectively on the face of the material before the court, the first 1997 outline permission had effectively failed to think about EIA. There was then a reserve matters approval in 2004, which was pursuant to the second permissions. That was the daughter essentially of the 2000 permission. And the analysis as to why the reserve matters didn't require EIA relied upon, amongst other things, the fact that outline permission had originally been granted for a business park with no EIA required. So they relied upon the earlier outline permissions as justifying the lack of a need for EIA. And it was the reliance upon the outline that it was said if the outline was unlawful, there'd been an unlawful failure at the outline stage, and that ought to be remedied. You see the way it was put: the appellant M sought judicial review, based decision not to require EIA and unlawful, and so on. Curiosity of this case is Mr. Moores and I were both pupils at the same time, actually were in court for the High Court as watching argument. 205, you see the section 4, the formal validity of the two outline permissions and the screening opinion in respect to the second as the defence. The judge who was Mr. Justice Stephen Richards, as he then was, this is Lord Justice Old who's speaking for the Court of Appeal, but the judge didn't determine whether either the two outline permissions would have been quashed if there'd been a challenge within time. He relied upon their formal validity as a bar to direct or indirect challenge. And this is how he put it, and I endorse the analysis the judge, as indeed the Court of Appeal did, but the language is quite helpful in my submission. So the starting point must be the validity of the outline permissions. They weren't challenged at the time. No application to challenge them out of time, no realistic prospect of extension being given for that, and a basis of well-established principles, including Hoffman, Roche and O'Reilly, they must be given, and it's just the phraseology I endorse, it's quite a nice snappy shorthand, they must be given all the effects in law of valid decisions. Those circumstances, the counsel plainly entitled, when considering the application of RM approval, to have regard to the early decisions and assume that they'd been lawful in EIA terms. Don't do an investigation whether they had or hadn't, you just proceed on the basis. So that the analogy here would be when you're at a discharge condition stage, you proceed on the basis that what happened earlier was Regulation 70 compliant. You don't conduct an investigation as to whether it was or wasn't. That's essentially my submission, the popular approach. Paragraph 38 the two strands of the argument for the Forward Court of Appeal. One was on domestic law and one was on EU law. So Richard Gordon case he submitted, QC as it was, as a matter of domestic law, formal validity can't provide a defence to the challenge. You maintain courts recognise unlawful reasoning one planning decision may vitiate a later one. Don't need to dwell on the reason you've got. You can see it there. In 42, as Ms. Robinson, Alice Robinson and Mr. Katkowski submitted, the domestic law principle is clear. It's correctly applied by the judge, namely, administrative acts are valid unless and until quashed by the court. We then see some of the case law the judge referred to, plus the Corbett case and others. 43 is important when considering the principal effectiveness. As Mr. Katkowski observed, the principle doesn't remove the possibility of challenge. Rather, it allows the regulation of challenge in respect to forum, standing and timing, all in the interest of efficient decision making. I would add there, actually also in the interest of preservation of legitimate expectations and the right see A.G. Cocotte in the Irish case. And so on. You see the word, I won't read
Well,
it
that would be a claim for judicial review potentially well beyond the 3 months,
Yes.
as it then was. Didn't it?
Yes, indeed. I mean, very occasionally there was one about hotels in the north of England. I think that was made out.
Right.
In maybe one of yours.
It was.
They are obviously right.
The case, not the hotel.
Yes, yes, indeed. But that there was, I think, there was a degree of concealment, wasn't there, in that case, or
Indeed.
malpractice.
Yes. Well, let's say
Yes.
the facts weren't
Well,
fully
usual.
fully on the surface. Yes.
Yes. Thornton
Hall.
Correct.
So then paragraph 44, you see then very clear law, and on the fact Noble can't now challenge directly or indirectly either the outline planning commissions or the screening decision relation second of them. The challenge at the approval of reserved matters stage not to require EIA isn't in effect an impermissible collateral challenge to those decisions. And I say, well, insofar as it is right to analogize to EIA from habitats, which my learned friends say it is, then similarly, a challenge to saying at discharge and condition stage, because something's gone wrong at the grant of permission stage, you can't have your tree approval because you have to assess the whole development is doing precisely what the Court of Appeal said couldn't be done here. And so I highlight 45, etc. And then at 46, we get to the effect, does EU law make a difference to this? Answer, no. Reasons in the section that follows. So you see how Mr. Gordon formulated it is there was reference to Wells, which is one of the leading judgments on procedural autonomy. Wells and the court made clear that that principle was subject to principles of equivalence and effectiveness. And you see that over the page, actually. So it's 49, you see the quote, in Wells, the detailed procedural rules applicable are a matter for the domestic legal order of each member state under principle of procedural autonomy, provided that they're not less favourable than those governing similar domestic situations, principle of equivalence, and they don't render impossible in practice or excessively difficult the exercise of rights confirmed by the community legal order, principle of effectiveness. And essentially, the argument being put by Mr. Gordon was the formal validity principle infringed the principle of effectiveness and therefore couldn't withstand EU law. That was essentially the argument put. You see how the court deals with this so there are 53. You see in particular by reference to the well-established principle of effectiveness, Mr. Gordon submitted ... Then can I ask the court to go over to page 50, paragraph 57. You see that Mr. Robinson and Mr. Katkowski submitted the domestic law principles regarding formal validity not inconsistent with Wells or the EU principle of effectiveness. There's a piece of effectiveness because the ECJ has its own time limitations for judicial review of EU acts. 58. On the simple issue whether domestic procedure rules infringe the principle of effectiveness by rendering the exercise of relevant community rights impossible in practice or excessively difficult, by firm views it doesn't. And then you see how 59, there's reliance on how the European authorities also place importance on legal certainty and the considerations that in domestic law give rise to the principle of validity of unchallenged decisions. And then putting it together at 61, find the principles. If the two outline permissions, either two outline permissions required and or were not the subject of valid screening exercise, there was a clear domestic remedy. I would say substitute that if the permissions in the present case had breached Regulation 70 or whatever the predecessor regulation was, there was a remedy. If exercised promptly, for quashing. The domestic law requirement of promptness in the exercise of the remedy strikes a reasonable balance between the need to provide a remedy and the public interest in effective administration, planning controls and legal certainty. And we know, as I say, from Advocate General Cott in the Irish case, paragraph 42 to 46, that for extant consent, as opposed to the expired one in that case, legal certainty is a consideration. You saw how she considered that. So I say the respondent's approach is inconsistent with Noble, which remains good law. It's consistent with Advocate General Cott, and essentially involves the proposition that at the discharge of conditions stage, a decade after outline permission was granted, and several years after reserved matters and the foul water condition approval was granted in 2018, you can re-examine the early decisions to see if they were effectively compliant, as opposed to what we say, that the Noble approach would be to proceed on the basis that what Regulation 70 required to be done was done. It may or may not have been, but one doesn't do that investigation because you then go down the rabbit hole that Noble says one shouldn't do, with all the consequences for certainty. I say that's buttressed, not only by Friends of the Irish Environment, which we've got, but buttressed by Gleeson, which I think is the last case I'm taking the court to. Gleeson is at tab 17. Not my happiest memory of being in this court, the Secretary of State. You may have been in the case, my lord. I can't remember. No, what had happened is the Secretary of State has said to the planning inspector, "I like to decide this one for myself." The recipient of the email confirming that was away on holiday. The message never got through to the inspector. The inspector sent out the decision notice. Yes, you should have seen the emails in your disclosure. But yes, that didn't go down very well. So they issued a decision that the Secretary of State didn't want to issue. And the Secretary of State then issued a substitute decision. And an issue arose as to whether that was valid. In fact, the Secretary of State sought to withdraw. Different context also, but what I do rely upon is at 24. He said it's another case of Mr. Justice Cranston had accepted Mr. Swift's and my arguments on behalf of the Secretary of State that it was possible for the Secretary of State under either incidental or common law powers to withdraw a decision issued in error. And at 24, the judgment of Lord Justice Sullivan noted a planning commission confers a substantive right, often a very valuable substantive right, irrevocable, save on the procedure contained in sections 97 to 100. That is in your clip, FYI. But for those who may not know, there's a statutory power to revoke or modify a planning permission with a concomitant requirement for compensation. Now, obviously, Gleeson was factually very different from the present case, but it's a further recognition of what Advocate General Cott called the legitimate expectation that runs the planning permission, which is part of the underpinning of the Noble principle. That if it's not challenged in time, then the principles of certainty give way. That's why I say ultimately this is not a question about on analysis like lacunas or protection of the environment. The law protects the habitats by virtue of Regulation 70, but there's a time limit on enforcement. Have a section where the inspector went wrong, but I don't think it's essentially subject to the surface water point common ground. If I'm right on the law, the inspector did go wrong, so I'm not sure it would help you for me to go through that given the hour. On ground 3, lastly, I mean very fleetingly ground 3, and it's appreciating it's our last stand essentially, but what we say here is, well, if contrary to everything I've said so far, the Barker approach is taken whereby the agreement is of multiple stages, and you can read across that to habitats, contrary to everything I've said, then in my submission, the proper balance between the protection of environmental interests on the one hand and the kinds of interests we've just been looking at, certainty and so on, reasonable expectations, proper balance would be that the scope of the appropriate assessment at any one stage should reflect the scope of what's being agreed to at that stage, as opposed to reopening early decisions. That, in a nutshell, it's paragraph 47 of the skeleton argument. That's what we say on ground 3. Let me just check my notes. I think.
Yeah.
Well, unless you have any further questions, I'm only 17 minutes behind the original schedule.
Thank you very much. Thank you very much, Lord Banner.
Okay.
So, next, Mr. Mills.
Thank you, my lord. May it please the court. Just by way of introduction, I'll outline in headline my response to each of the 3 grounds.
Yeah.
And then I'll begin by responding to grounds 1 and 3 together, the poor interpretation of the regulations,
Right.
and then deal with ground 2 in the light of what the European regime is, given that paragraph 181 is seeking to apply that regime. So it makes sense to look at the regime first.
Yeah.
So the 3 basic issues on the appeal are, firstly, can an appropriate assessment be required at the condition discharge stage under the directive and the regulations? In my submission, the answer is yes. There are 3 routes to that conclusion. Firstly, on a purposive interpretation of the regulations on ordinary domestic principles. Secondly, by applying sections 2 and section 6 of the Withdrawal Act 2018. In other words, the regulations are EU-derived domestic legislation which fall to be interpreted in light of retained case law. And my submission will be that neither Route 1 or Route 2 produces a result that is contra legem.
Yeah.
Then the third route would be through direct effect of Article 6.3 itself, via Section 4 of the Withdrawal Act 2018. That is very much a fallback, which only needs to be considered if an interpretation of the regulations to require assessment at that condition discharge stage were contra legem, and then I would be urging the court to apply the direct effect of Article 6.3 together with Section 5 of the Withdrawal Act, which retains the principle of supremacy. So in answer to my Lord Justice Singh's question, I imagine that is why Sir Ross Cranston dealt with Section 4.2b, because it's that fallback if the appellant is right.
You may be right. I mean, we don't need to parse his judgment because we really want to get the answer right ourselves. But I'm not sure that is what he was doing, because he seems to conflate that exercise with the exercise of interpretation. It may not matter.
Well, in my submission, the correct way to deal with it is in the hierarchy I've outlined: domestic principles of interpretation, Section 2 and Section 6 through the Withdrawal Act. Only if that is contra legem does one fall back on Section 4, Section 5 and direct effect. And there are 2 lines of cases, 2 lines of authority that are relevant to that interpretation exercise. The first is a series of cases dealing with what is meant by agree under the directive, and that's Friends of the Irish Environment, Inter-Environment and Wallonie, and then the 2 domestic cases, the court has been taken to Wingfield and Swire. The second line of authority that bears on the interpretation of the directive and the regulations is the case law requiring a strict precautionary approach given the substantive nature of the protection in the legislation. And I'll take the court very briefly to Wyatt and Dutch Nitrogen, which effectively summarise the relevant jurisprudence on those points. So via those 3 routes, applying those 2 lines of authority, I will seek to establish the proposition that appropriate assessment can be required at the condition discharge stage. The second issue before the court is whether an appropriate assessment at that stage is confined to the variables left over by the condition. In my submission, it's clear from the wording of both the directive and the regulations, together with what is said by the Court of Justice and House of Lords in Barker and in Inter-Environment and implicitly in Wingfield, that the assessment must be of the whole project, the effects of the whole project, rather than just the effects of the reserved matters application or the condition discharge. And that is of a piece with the precautionary substantive protection nature of the legislation. And then the third main issue before the court is whether the inspector was entitled to consider the impact on the Ramsar site when exercising his discretion to discharge the various pre-commencement conditions. And as I will come to show the court tomorrow in my submission, there was a direct nexus between discharge of the condition and the effect, because discharge of the conditions was the implementing act that rendered the development lawful in terms of domestic planning law. The principal authority my learned friend relied on to establish that his proposition that the assessment is confined to the conditions themselves was Medina. What Medina actually shows, and I'll take the court to this tomorrow, is that one asks whether the decision maker is abusing their power or acting irrationally. The section of the judgment the court was taken to was dealing with a different point, namely whether the condition was a negative Grampian condition, and that's why the court said one needs to look at the words of the condition. It was dealing with that submission earlier in the judgment. It's expressed in terms of purposes and rationality. So that's hopefully a short route map of where I'm going with my submissions. Turning to ground 1,
Would you pause just for a second, because I find myself having exhausted 3 writing implements without the means of writing. So, I've got one. My lord has come to my rescue. Thank you very much. I'm sorry about that. It's never happened before. I've never gone through 3 in an afternoon. Sorry.
I was going to start with Hughes and direct effects. As I said, there are 3 routes into the 2 lines of jurisprudence I rely on. I don't think I need to take the court to section 2 and section 6 and principles of domestic interpretation. I hope I can take those as read. The only slight issue might be section 4.2b. So I'd like to show the court Hughes, where in my submission this court did grapple with the effect of that provision. It's tab 28 of the authority.
Which tab?
28, my lord. And when one looks at the judgment and sees what the court did, effectively the court took the obligation to be the directly effective obligation in Article 8 of the relevant directive, and then it reasoned by analogy with Court of Justice case law to establish what the content of that obligation was. And the parallel I draw in this case is Article 6.3 is clearly directly effective. The Court of Justice held so in Vadensay. The High Court in Harris confirmed that that was the case, and it is legitimate to reason by analogy with Barker, Friends of the Irish Environment, and Inter-Environment to establish what the content of that Article 6.3 right is. The facts are slightly heavy going. They're set out in the head note. Starting at just below letter D, the claimants in that case were members or surviving spouses of members of 4 occupational pension schemes designed to provide final salary pensions. Following the insolvency of the employers, the pension schemes had insufficient assets to meet their protected liabilities, and so they were transferred to an organisation called the Pension Protection Fund, which was the UK guarantee institution. Under the Pensions Act 2004, the fund provided 100% of the benefits under the employer's scheme to members who had attained pension age by the time of the insolvency, but the compensation was limited to 90%, which is just between E and F, in the case of employees who had not attained pension age by the time of the insolvency. Then the last line on page 593, a surviving spouse of a member in receipt of compensation from the PPF would get compensation limited to half the annual rate of compensation which the pensioner had been entitled to. And then over the page, the valuation of that entitlement and compensation was carried out at the date of the insolvency using various actuarial assumptions. We can see reference between A and B to a ruling of the Court of Justice. That was in a case called Hampshire and Board of Pension Protection Fund. So the Court of Justice ruled that Article 8, which in Directive 208/94, which was on the protection of employees in the event of the insolvency of their employer, was directly effective. So a clear finding of the Court of Justice, Article 8 is directly effective, and it requires member states to guarantee compensation which corresponds to at least 50% of the value of the accrued pension entitlement. So following that ruling, the PPF adopted a method of determining payments by conducting a one-off valuation of the benefits payable, comparing the amount of compensation that the fund would pay over time, and there would be a balancing payment in order to comply with the Court of Justice's ruling. The claimants, we see this just above letter C, brought a claim for judicial review, and they brought 2 grounds. One was that the method of assessing compensation was incompatible with Article 8. The second was that the statutory cap on compensation constituted age discrimination, which was unjustified and therefore unlawful. Mr. Justice Lewis allowed the claim, and he held that the cap amounted to age discrimination and that the method of calculating compensation failed to comply with the Court of Justice in Hampshire, among other things because it didn't deal appropriately with the surviving spouses of the member of the scheme. From the holding, we can see that the Court of Appeal allowed the appeal, and the relevant part is part 2 of the holding at the foot of 594. When a member died, the surviving spouse would be identifiable as a member of a class who had a directly effective Article 8 right. But the court held that Article 8 didn't give rise to freestanding protection to surviving spouses' right, and therefore it wasn't necessary to carry out an additional standalone valuation for when the member died. And in reaching those conclusions, in my submission, the court was showing how Section 42B of the Withdrawal Act applied. So the court has been taken to paragraph 50 at page 603. Common ground that, to the extent the points in issue turn on the interpretation of the directive, case law of the Court of Justice, EU exit doesn't have any impact because of Section 42B. The point's even clearer though when one looks at the court's analysis, which begins at paragraph 117 on this particular point, page 629 of the bundle. So in paragraph 17, the court first considered whether Article 8 conferred a directly effective right on survivors, and the PFF submission was it did not. Firstly, because the identity of survivors was not conditional or sufficiently precise, and also because Section 4.2b meant that it was too late for the court now to recognise such a right. So PPF was relying directly on 4.2b. The Court of Justice decision in Hampshire is then referred to in paragraph 118, where the Court of Justice had given Article 8 held it that it did have direct effect. The Court of Appeal notes in the last sentence, it's clear from Hampshire that the rights referred to in Article 8, including survivors' benefits, are directly effective rights for members. But they noted then in the next paragraph that the Court of Justice didn't consider whether Article 8 conferred a directly effective right on survivors. And it goes on to say, unsurprisingly, there's therefore nothing in the reasoning of the Court of Justice which expressly deals with their position, and it's not possible to deduce from Hampshire that survivors do or do not have directly effective rights. So the court didn't stop there and say Section 4.2b, that's a complete answer. There is no recognition of the particular obligation in relation to survivors. There's nothing of a kind. What the court did is start from the proposition that Article 8 of the directive had been held to be directly effective, and it then analysed what the content of that right was by analogy. And the first analogy at the top of page 630 was the decision in Collateral of the Court of Justice, which wasn't a pensions case under that directive. It was an equal pay case dealing with Article 119 of the EEC Treaty. So the Court of Appeal firstly looked at the analogy with Collateral, then just above letter G on that page, the second line of authority it reasoned by analogy with is a case called 10 over, which was a sex discrimination and equal pay case. And by analogy with both of those two lines of authority, in paragraph 124, the Court of Appeal concluded that survivors become identifiable as and when the pensioner employee or ex-employee dies. At that point, they do have a directly effective Article 8 right by analogy with Collateral and 10 over. And we see that conclusion confirmed in the last 5 lines of paragraph 125, rejecting the PPF's argument, saying it's a non sequitur to conclude that no survivors can have rights once members who were receiving compensation died. The survivor then has a crystallised directly effective right. And the Court of Appeal in my submission in this case is reaching that conclusion by properly applying Section 4.2b. The obligation that has been held to be directly effective is the Article 8 obligation, and then it's determining what the content of that is, and that doesn't offend the terms of Section 4.2b. So with that in mind, I think I can give you the references to Vadensay. I don't think we need to turn it up. It's Vadensay is tab 12.
Vadensay, yes.
It's tab 12 of the bundle. Page 177, paragraph 19.5 is the question referred. And paragraphs 69 to 70, the Court of Justice concludes that Article 6.3 has direct effect. And again, for your note, the High Court, Mr. Justice Johnson in Harris, which you have at tab 31, at page 831, paragraph 90, he confirmed that reading of Vadensay, that Vadensay establishes that Article 6.3 is directly effective. In my submission, the obligation that Section 4.1 of the 2018 Act preserves is the obligation in Article 6.3 not to agree a project unless the competent authority is certain that it will not adversely affect the integrity of the site. That is the substantive obligation in that directive provision. The relevant question for this court is what is meant by agree in a multi-stage consenting process. And that, in my submission, is an issue about the content of the obligation. And just as in Hughes, this court is able to determine the nature and scope of that directly effective right, even if the specific issue has not been addressed by the Court of Justice. So in Hughes, the ability of survivors to invoke Article 8 of the directive in that case could not be deduced, we saw, from the Court of Justice case law on the directive, yet it was legitimate to use analogies from other areas of EU law to determine the content of the obligation. Here, the relevant case law that I'll take the court to, I think, hopefully shortly, does determine what agree means. There's an express finding in the Friends of the Irish Environment decision that agree should be construed in the light of development consent in the EIA directive. So there is clear Court of Justice case law on the specific point, what does agree mean? The same in Wallonie. Before I go to Inter-Environment and Wallonie, though, I'd like to just return briefly to Barker, because both Inter-Environment and Wallonie draw on the EIA case law. So I just want to add a couple of points on that case law. So tab 14 is the preliminary ruling in Barker. The two parts I would like to go to. Firstly, page 228. Sorry. So 224. So it's paragraph 48 of the Court of Justice's ruling in relation to the question referred by the House of Lords. So this judgment's in two parts. First part dealing with the question referred by the House of Lords. Second part, which I'll come to in a moment, deals with infraction proceedings brought by the Commission. So paragraph 48, the Court of Justice said that if the National Court therefore concludes that the procedure laid down by the rules at issue in the main proceedings is a consent procedure comprising more than one stage, one involving a principal decision and the other involving, and I emphasise, an implementing decision, which cannot extend beyond the parameters set by the principal decision, it follows that the competent authority is in some circumstances obliged to carry out an environmental impact assessment in respect of a project even after the grant of outline planning permission when reserved matters are subsequently approved. So first point is the language there is apt to include pre-commencement conditions as well as reserved matters. The judgment is expressed in whether there is an implementing decision, i.e. the thing that authorises the project to go ahead. And my submission is that a pre-commencement condition is a particular form of condition, no different in that respect to a reserved matters condition. They are all forms of condition, depending on the facts and circumstances of the case. One or other will be the implementing decision, i.e. the thing that as a matter of domestic law needs to be approved to lawfully carry out the development. Next relevant point is the last sentence, 48. That assessment must be of a comprehensive nature so as to relate to all the aspects of the project which have not been assessed or which require a fresh assessment. In my submission, that's fatal to ground 3. The assessment is of the whole project. There is no suggestion in Barker that the reserved matters, except it's an EIA case, a fortiori in my submission in the case of habitats, which is a substantive protection, no suggestion that the assessment is confined to the issues raised by the reserved matters application as opposed to the whole project. Then within the same tab at page 230, paragraph 99, this is now dealing with the infraction proceedings brought by the Commission. Effectively on the same point, the Commission said the UK hadn't properly transposed the directive. because it didn't allow for EIA at the reserved matters stage. And at page 230, paragraph 99, the UK argued that Article 2.1 of the directive makes clear that a project must be subject to an assessment before consent is given. That consent, the UK said, is given when the outline permission is granted, and not when the reserved matters are subsequently approved. And that the UK's rules correctly transposed that. That was rejected by the Court of Justice. Paragraph 100, development consent is defined as the decision which entitles the developer to proceed. Common ground that under national law in paragraph 101, the developer can't commence works until he obtains the reserved matters. And so until you get your reserved matters, the development in question is still not entirely authorised. Therefore, the two decisions in paragraph 102 must be considered to constitute as a whole, i.e. a multi-stage development consent. In my submission, again, that is entirely inconsistent with the appellant's proposition that the outline permission in this case was the consent. It was part of the consent, just as the reserved matters approval and the discharge of condition 7 on the outline consent was part of the necessary approvals, but there was a missing part of the jigsaw, which was discharge of all of the pre-commencement conditions on the reserved matter. They are implementing decisions, and in my submission it's clear from the rejection of the UK's argument in this case that they must be considered as a whole as the consent, rather than simply the outline permission or the outline permission plus some of the other consents that the developer has obtained in this case. So then at 105, 106 on page 231, the court concluded that the UK rules preventing EIA at the reserved matters stage failed to transpose the directive, and the declaration, paragraph 1 of the declaration, was a failure to transpose. I'm mindful of the time. The next port of call is the House of Lords in Barker.
Well,
I think that will take slightly more than 3 minutes.
We do have to stop at 4:15, as I said at the outset. So I think we'll call it a day there, but we are well on track to finish at...
We are. I've just got to go briefly to Friends of the Irish Environment, Wallonie, say a little bit about Wingfield and Swire, and that's largely going to complete my submissions on grounds 1 and 3.
Right.
And then I think I've got maybe half an hour on ground 2.
Right. So we'll finish by 1 o'clock
Indeed.
tomorrow, which we must do actually.
Yes. Yeah.
All right, fine. Well, we'll sit again. We don't need to sit early to do that. We'll sit again then at 10:30 in the morning. Thank you very much.